Hi, my name is Jackie Gutierrez. I am with the California Restaurant Association, and this is Ask CRA on the Confidential Bulletin. Today, I'm joined by Laura Pearson Scheinberg and Kimia St. Pierre from Jackson Lewis, one of our CRA Legal Center partners. Thank you both for joining us. I'll go ahead and turn it over to Laura.
Hi there. My name is Laura Pearson Scheinberg, and I co-lead our labor relations practice group as well as our retail industry group. And CRA has been a wonderful partner to us, and we're regularly in front of them. Our law firm at Jackson Lewis does everything basically at work, labor and employment law, immigration, anything that you really come into impact at the workplace, OSHA, et cetera. And I'm out of our San Francisco, primarily, and also our Baltimore office. And I have here with my very dear friend, Kimia St. Pierre. You wanted to introduce yourself?
Sounds great. Thanks so much, Laura. Hi, everyone. My name's Kimia St. Pierre. I'm a principal in our Orange County office, and I'm really excited to be here with the California Restaurant Association. I work closely with restaurant employers across the state, including quick serve concepts and restaurants operating within hotel properties. So, like Laura, I understand how fast paced and operationally complex this industry can be. Like Laura, I regularly advise on California wage and hour compliance, leave laws, discrimination, harassment prevention, and I also support employers through union organizing campaigns and other traditional labor issues. Our goal is always to provide practical, business focused guidance that helps restaurant operators stay compliant and focused on delivering a great guest experience. So I'm excited to be here with you.
I'm so excited too. And today we're going to talk about work, speech, and rights, navigating political expression in the modern workplace. So, what in the devil does all that mean? What is political speech at work? It's a hot issue in today's politically polarized climate. And our goal is to essentially say that, number one, workplace speech is not just controversial, it has real legal and cultural implications. So, Kimia, is political speech protected by the First Amendment at work?
So, no, the First Amendment does not prohibit adverse action against employees for political comments that they make in the workplace, but other laws do come into play. So, first, the First Amendment doesn't protect speech that incites violence or lawless action, legitimate threats, or are defamatory under the law. But it also doesn't prevent employers from restricting political slogans, requests for political donations, or distribution of political materials in the workplace. That means that employers can lawfully discipline employees for certain speech. So that would include speech that would potentially implicate discrimination and harassment laws, trade secrets, confidential company information, and patients' medical information in the medical field. So, of course, this leads to the frustrating answer for private employers who want to discipline employees for political speech. Well, all of that depends on what is said. So, federal law does strike a balance between affording employees the right to discuss their working conditions, but it does not give employees the right to disrupt their workplace or create a hostile work environment, which then employers could find themselves liable for. And so, with that, which laws do impact employers when handling political speech?
Well, our near and dear favorite, Kimia, the National Labor Relations Act. As labor lawyers, this is what we live and die by, right? So, the National Labor Relations Act, the NLRA, deals with this kind of issue, falls in with that protected concerted activity. So it doesn't matter whether you are unionized or not. So don't shut down now that you heard me say that. This actually applies to union and non-union workplaces alike. So the National Labor Relations Act protects employees' rights to join their coworkers, to raise concerns about working conditions, and to advocate for better terms and conditions of employment. These protections will extend to social media posts too. I have so many clients that get so frustrated when they see social media posts and they want it removed immediately. They want to do things right away. But in order to be protected under the NLRA, employees must act in concert. That means one on behalf of others or two together for their activities to be protected. So employers can restrict employees from engaging in political speech only if it creates a hostile work environment. It cannot prohibit such speech when there is a direct link between the issue advocated for and an employment concern raised. Now, remember, political speech that we might be hearing and seeing from our workers right now really aren't connected to workplace issues necessarily. So it's an individualized inquiry that we have to look at very closely. Employers can restrict employees from engaging in political speech that creates a hostile work environment, but cannot prohibit speech when it's that direct relationship. So political speech that goes beyond the protections of the NLRA, i.e. that's not linked to employment concerns and is purely political, can be restricted. For example, employers can prohibit political distribution of literature when it contains information sufficiently removed from the employee's interests as employees and simply endorses a candidate, for example. If a post that someone makes says, I do not or do support this candidate and nothing more, that's not something that's related to work. When employers engage in conduct that arguably violates the NRA, employees, regardless of whether they're represented by a union, again, it applies no matter what, can file what's called an unfair labor practice charge with the NLRB. Then the agency would conduct an investigation, which can result in complaints being issued with accompanying remedies like notice postings. If you gave discipline, you'd have to take back that discipline, any kind of back pay and reinstatement if you terminated the person for it, and other remedies like that. Anti-discrimination laws also play another role and can trigger lawsuits, which are different from ULP claims. Kimia, can you explain what laws come into play beyond the NLRA, please?
Yeah, so anti-discrimination laws implicate protected characteristics can trigger harassment claims. So what do I mean by that? So anti-discrimination laws protect employees from discrimination on a variety of protected categories. So examples would include race, color, religion, national origin, or sex. However, these anti-discrimination laws do not extend to protecting political speech. When employees engage in political speech, that does discriminate against employees on some of these protected bases, or any rather of these protected bases. Employers may find themselves subject to lawsuits for creating hostile work environments and failing to take corrective action when they're put on notice of the discriminatory conduct. But generally speaking, the best policy is to adopt a neutral speech approach that allows employees to exercise their rights under California law and the NLRA. Even a neutral policy may require some political speech to be permitted, as noted above. But once that speech arises to the level of being discriminatory against a protected class or hate speech, for instance, employers can then crack down on that specific speech as it arises. Some states, including California, of course, have laws that provide broader protections for employee speech. So, Laura, can you explain what those laws cover?
Sure, you're talking about state off-duty conduct laws, which whereas some states protect lawful political activities outside of work, and you know it, California is one of them. So in California, employers cannot discipline employees for expressing their personal views unless they clearly and materially impact the employer's business. California's labor code prohibits employers from enforcing policies that prohibit or prevent employees from participating in politics or from controlling the political affiliations and activities of employees. Similarly, the California Labor Code prohibits employers from taking adverse action against employees who engage in lawful political activities outside of the workplace. So, employees must be reinstated and reimbursed for any lost wages and benefits if they are fired for out of work political activities. So, when we're thinking about this, you have to think about each law and say, go down that checklist. So, NLRA, is there a problem there? Then you look at the state and federal discrimination laws, and then you have to think about these off-duty conduct laws. Kimia, what else is new?
So recently, we had a bill, SB 399, which also prevents employers for taking adverse action against employees who refuse to participate in employer-sponsored meetings or communications on political matters that are not related to their job duties. So, practically, what does that mean? That usually comes up in the labor organizing arena when employers would like to host meetings for employees where they can learn more about organizing and the impacts that it may have on their workplace. So, with that background, let's walk through a hypothetical situation of things employers should consider when faced with employee social media posts outside of work. What happens when an employee posts about politics on their personal social media outside of work hours? Is that off limits to employers or is something more?
So, as an initial response, I just want to raise an issue that I always say in training. Should you be social media friends with with the employees that you supervise? Should you be social media friends with your coworkers? Because once you see that, you can't unsee it. And so just food for thought, particularly if you're a manager and they're talking trash about you on their social media, chances are you're not going to have a lot of ability to do something about that. Don't want to be accused of treating someone differently for something that they're allowed to do. So, just food for thought before we get into this hypothetical. That makes me think personal social media outside of work hours, off limits to employers. I hope you don't even see it. But if you do, under federal law, the NLRA protects employees' rights to communicate through channels outside of that immediate employee employer relationship, including on social media outside of work hours. Rules cannot be reasonably interpreted by employees to prohibit them from engaging in protected activities online and beyond the workplace. So it has to stay relevant to the job and to the workplace. Consider it this way. Employers can't prohibit union organizing activities outside of the workplace, nor can they prohibit protected social media speech beyond the workplace either. Kimia, what about state law?
So, under state law, we have similar restrictions that apply to the extent that employers can curb employee speech that causes direct business harm. So, off work speech restrictions need to be narrowly tailored and not simply prohibit political speech altogether, even if the employee is of a political opinion the employer disapproves of. There must be a nexus between the speech and the adverse material business impact. So, if employers are ever unsure if this speech crosses the line, this is when consulting with counsel becomes a really important move because case law will address the content of the speech on a fact specific basis. It's very unlikely that you're going to have a one size fits all prohibition rule that'll apply in any given situation.
So it's that darn lawyer answer, it just depends. As you can tell, without clear cut, hardline rules on how to police employee speech outside of work, determining how to take the right legal approach is also challenging. But beyond this, political posts on social media can affect the workplace dynamics and impact employer risk. Obviously, the world is a really crazy place right now. It's very polarized. There's lots of opinions. There's lots of very strong feelings on both sides of the issues. And these issues, these political issues, create great divisions in the workplace. And they're very, very hard to navigate. They create the impression that the employee is speaking on the employer's behalf. So that is something that you can restrict and have a policy about. If you're going to do any social media postings, employee, I have a policy as the employer that says you cannot speak on my behalf. Every day, that will be lawful. You also want to factor into claims this idea of discrimination, harassment, and hostile work environment against the employers by other coworkers, right? So if you're getting complaints by other employees about posts that their coworkers made and are making them feel a certain way, et cetera, that creates another dynamic for which you're going to have to think through and weigh those risks that are often best done with counsel. Employees can also claim that employers' response to political discussions is pretext for illegal discrimination against protected class status. You know, it is a minefield, and that's kind of why we're talking about it today, to sort of bring to you some of, like, it's not just a simple yes or no. It's not, a gut reaction. You kind of have to go through on a case by case basis all these things. State restrictions also cause additional legal concerns for failing to address unlawful speech. So it really is a quagmire. How about for California?
So, California, of course, has its own state laws that protect employees from discipline for lawful off duty conduct. So, what does that mean? That means employers cannot fire employees for their political opinions expressed outside of work generally. But once that conduct affects the business or crosses into discriminatory, harassing, or threatening colleagues, employers then may have more rights because the conduct disrupts the workplace and opens the employer to liability. So, in these cases, employers now have a viable argument that the off duty posting may undermine their business or reputation and proceed with discipline. As with everything in this area, it's going to be a very fact specific question. And so, once again, employers will need to be careful and consult with counsel prior to disciplining employees for what they say outside of work. Federal law is similarly challenging to navigate in this area. And so, I'm going to turn it over to you, Laura, to talk to us a bit about federal laws.
Federal law also protects employees from disciplining for lawful off duty conduct. So, again, under the National Labor Relations Act, employees are protected when they make social media posts in concert for their mutual aid and protection, and there's no overriding employer interest that exists. So, i.e., they're bringing a claim or post on behalf of fellow coworkers, etc., even on, the hot button immigration issue right now, for example. This protected activity can include recording images of protected picketing, documenting unsafe workplace equipment or hazardous work conditions, documenting and publicizing discussions about their terms and conditions of employment, i.e., what they're going on at work, if they're showing an unsafe situation or if they're showing a group of employees like complaining or that kind of thing, documenting and publicizing discussions about their terms and conditions of work, documenting inconsistent application of their employer's rules, or requests to preserve it later for use in an administrative or judicial forum in an employment-related action. Under the NLRA, employees are not protected if they say things about their employer that are egregiously offensive or knowingly and deliberately false. Now, this is kind of a high burden, right? It's not opinion. It's something that is very offensive to the reasonable person, egregiously so, and that they know and are deliberately making false statements. So essentially, defamation, for example. Social media policies become unlawful when they have a reasonable tendency to chill employees from exercising their protected rights. However, an employee can rebut the unlawfulness of a policy by showing that the policy advances a legitimate and substantial business interest and that the employer is unable to advance that interest with a more narrowly tailored rule. How about social media policies and the like?
So, social media policies and discipline resulting from those policy violations, again, must also be narrowly tailored. So, for example, the NLRB has found in recent cases that policies were lawful, meaning they were okay, when they prohibited statements that threatened, defamed, or harassed any person, that contained or promoted unlawful hate speech, violated a company policy such as, the code of professional conduct, conflict of interest, or any policy relating to relationships with or treatment of patients in the healthcare industry. They also found cases where the policies were lawful that resulted in unauthorized disclosure of trade secrets or proprietary confidential information, or violated HIPAA or exposed protected health information. Conversely, however, the NLRB has found more generally worded policies like those just prohibiting behavior that publicly embarrasses an employer or prohibiting inappropriate discussions on social media to be unlawfully overbroad. So, real world context, current news shows employers increasingly monitoring and disciplining social media sometimes have real legal blowback. And so, when does a personal post become an employer concern?
Well, when it implicates the company trade secrets or other confidentiality concerns, or when it contains egregiously offensive information, or is knowingly and deliberately false and published so, When it's assessing a post, an employer should put themselves in the position of the poster and consider whether the employee knowingly misrepresented the information or if they were incidental falsehoods that would be protected. The misrepresentations must knowingly be made. When an employee posts as if they're speaking on behalf of the employer themselves, that similarly crosses the line. When an employee posts negatively references protected classes. This is not all to say that employers cannot take preventative steps to reduce the risk of liability from combating employees' off work speech. So, Kimia, let's walk through some of those practical measures that can position employers to navigate this landscape effectively.
Sure. So the first practical pointer would be to develop clear policies. So define acceptable expression and limits. So what do we mean by that? Consider a neutral policy approach that permits employees to engage in political activities as permitted under California and federal law. Employers run the risk of including prohibitions on specific activities that may then be construed as forbidding protected speech. And so that's why a general approach is a much easier way to avoid liabilities. This is especially true if a policy specifically outlines prohibited political speech or social media publications include a savings clause language that clearly states that the employee's protected rights under the NLRA are not intended to be infringed upon. So you can include some type of savings clause to the ideas to the extent that they have language like, nothing in this policy is designed to interfere with the rights of any employee pursuant to the NLRA or any other applicable law or regulation. You can include statements where the employer commits to respect employees' rights to use social media for organizing or other lawful purposes. Statements that the employer adheres to all relevant state and local laws regarding electronic communications also can be used as a savings clause in these policies. So overall, just want to note that the employer, is taking care to have these saving clauses outlining that they are not seeking to, chill speech. It's just to make sure that they're generally compliant with the employer's policies overall. Any other practice pointers, Laura?
Yeah, so let's clarify expectations and potential disciplinary consequences. You need to make sure that they know this rule will violate X. The more clear you are, the better off you'll be. So indicate that employees will not be disciplined, for example, for engaging in protected activities under federal law. That's another savings clause idea. Indicate that certain speech that is harassing, discriminatory, or obscene, depicts unlawful acts, shares confidential company information, or contains threats will result in discipline. And to that end, specifically tailor policies to address unprotected speech that does not concern employees' advocacy for change in the workplace. I know you have some more too, Kimia.
Yeah, so another practical pointer is to, of course, apply the policies fairly and consistently. This is important to avoid the perception of bias or targeting based on specific political opinions. You don't want to discriminate against employees for holding certain political positions or beliefs or posting about them in any way that does not materially affect the business. You want to make sure speech policies are enforced consistently. If they're applied more harshly to employees in a protected class, for instance, this could appear that the policy is being used as a pretext for discrimination. I know we've got more pointers.
Yeah, culture always matters, right? So promote respect and inclusivity always. Culture matters most, just as much as compliance. People, you want them to come to work and feel the culture of the workplace is a positive one. How about anything else, Kimia?
Yeah, so we've talked a lot about the policies, but the policies are going to be enforced, of course, by our team. So, what does that mean for us? That means as employers, it becomes really important to train and educate your managers to handle these discussions appropriately. You might have the world's best policies, but if you've got managers who are out there doing their own thing, not following the policies as written, we're going to run into problems that way. So ensuring that the managers understand the policies and are applying them correctly is paramount to having a positive workforce that is following the law as appropriate.
And how about that darn California? Those laws are changing every day. It keeps us busy. So you need to monitor those applicable state laws. At our law firm, we have a person whose job it is to monitor the California law changing. It is truly one person's full-time job to do that, just to get an idea of how extensive that is and what that includes. So make sure you're keeping apprised of all the state laws. Off-duty conduct protections vary by state, as we discussed. And since we're talking to the California Restaurant Association, we're obviously focusing in on California. But if you have locations in other states, make sure that you're taking account of those. But in California, check in on that labor commissioner's and governor's website as they post most frequent updates. The California Restaurant Association, Jackie and her team, they're very proactive about getting those updates posted on behalf as part of your membership. So just make sure that in your decision tree, you're thinking, let me take a quick look. Has anything changed in the law? Because chances are they very well could have. Anything else, Kimia?
Yeah, and so just to kind of round out the best practices, I want to revisit some of the things that you said earlier about culture in the workplace, because that's super important. So to ensure that your policies, really meet your goals, you want to make sure that they're reconnecting to your mission and your values. You want to focus on your organization's goals and collaboration, because that later gives the why behind policies, which can be useful when you want to explain the reasoning behind a corrective action that was given to an employee.
So, Kimia, we've been talking now for about a half an hour. I wanted to talk about some just closing thoughts and key takeaways. The legal principles that we've discussed today, it really is a checklist by which you should be using as you're going through sort of when a post goes up, what do I do? The first thing that I would say is don't overreact. Take a beat, take a deep breath, think about it. Should I even be seeing this? Is this widely posted? What lasting impact if this has? If I feed the post, if I feed the beast, if I give it attention, will it grow? Or should I just let it go? If you can't let it go, if it's over the line, if it does something, then make sure that you're looking at the limits under the National Labor Relations Act, under anti-discrimination laws, and those state protections. But when in doubt, take a beat. And if you still don't know, and HR doesn't know, phone a friend. Kimia?
Yeah, and that really focuses on, our best practices. What are the steps we want to take when it comes to social media policies? So, as we talked about, you want to make sure you're revisiting your policies so that they're not violating California law or the National Labor Relations Act. General policies are the best. Do we have our savings clause as needed in the appropriate places within the policies? Make sure our teams are being trained. If we are making changes to our policies, we've done our due diligence, we've updated them. Let's make sure we get our teams trained on them so they know what those changes are and are now enforcing the newest updated rules and have a refresher on how to handle the situation. To Laura's point, if they see something and, they say something, they don't go straight into spiraling and panicking over a post that's been put out by an employee. Of course, consulting counsel as necessary, especially when crafting the policies, and later should discipline be necessary based on any of these policies or conduct outside the workplace.
So I just want to thank everybody for spending some time with us and talking about social media. All I can say is when you read it and see it, just breathe and ask yourself, is this going to really impact my workplace negatively? And if so, then let's start thinking about it. I really appreciate your time, Kimia. Always fun to talk with you about any topic, but good to bring our friends into the conversation today. And we look forward to seeing you again.
Thanks so much, Laura.